We're with David Shapiro. David Shapiro is a criminal defense attorney in San Diego, California. He's agreed to answer some questions online that have been posted related to violent crimes. If you're in a situation where you've been charged with a violent crime and are considering hiring an attorney, one of the things I would highly recommend, take a look at some of the online client reviews, previous clients they've worked with. In the case of David, he's got some excellent client reviews from Google to Yelp to, well, Avo. I mean, he's got over 50 client reviews on Avo. And if you're not familiar with Avo, it also has other attorneys that do reviews based on that attorney and previous experiences with them. And he's actually got a perfect 10 out of 10. With that said, one more comment is you can also, if you have questions directly related to violent crimes and maybe a charge you're facing, he's agreed to answer those questions directly online. All you have to do is post them to the comments section below. If it's a situation where you're not comfortable posting that information on a public forum, you can also reach out to him directly. His office does provide a free consultation. With that said, David, let's go ahead and go into the first question that was posted. I was in a bar fight and hit a guy with a bottle. I'm being charged with assault with a weapon. This can't be right, is it?
Well, to be honest with you, my first inclination would be this can't be right that you'd be admitting you did something, a criminal act on a public forum such as this. But, yeah, it can be. Assault with a deadly weapon. A bottle can be a deadly weapon. A lot of things, you'd be surprised, could be considered a deadly weapon. I think what's important is, you're dealing with felony charges here. In the event the prosecution is alleging what's known as great bodily injury to the person you allegedly hit with the bottle, you could be facing up to 7 years in state prison at 85% of that time. So, I hate to break it to you, but it can be right, and it's time to, like I say a lot of times on my Avo answers, stop admitting guilt on public forums and start being proactive and get yourself the best attorney you can afford.
All right. Next question was, is the police intend to charge me with kidnapping? I took my son for 1 day to watch a movie, and my ex is pushing the issue. What do you recommend?
Well, I recommend you get yourself, again, the best locally experienced criminal defense attorney you can afford. And this is not just a sales pitch, it's the facts. Because, first off, the police may be arresting you or investigating you for kidnapping, parental kidnapping in this instance. But it's ultimately going to be up to the district attorney, not your wife, not the police, what, if any, criminal charges are filed against you. But the best thing you could do, particularly whenever there's a child custody dispute in there or an angry ex, is make sure you say as little as possible to that person and have your attorney that you hire, whether it's in family court or in this instance criminal court, be that liaison to the police, to the district attorney's office, to your ex-wife, to let them know that you're taking this case seriously and you're not going to corroborate or give them any information that they don't already have. The easiest example would be, it may sound stupid. Yeah, of course I was with my son. Why are you even admitting that? Let them prove it. My wife said I could have him for 6 hours. I took him back in 12. It wasn't like it was a big deal. Well, you say something like that, you think you're helping your case, but you just confirm the fact that you had your son 6 hours longer than the agreement was with your wife or your ex-wife. So there's a lot of things you could do to really screw things up, even if you think, this isn't kidnapping. Well, legally speaking, it might be. I have a lot of cases where we're dealing with issues where child custody sort of went awry, and one parent took the case into its own hand and said, hey, you know what, you're not fit to be with your mother, you're going to come with me. Legally speaking, that might be kidnapping. Whether or not there's a defense is to be determined. There's certainly a lot of mitigating factors in there, but why give them anything more than they already have?
Right.
Don't give them a case when there might not be there one.
Okay, all right. Next question, this final question we have is, do assault charges on a minor have higher penalties?
Depends on the type of assault. Sexual assault, absolutely. Regular assault, it will depend on the injuries. It will depend on the age of the minor. There's a child abuse enhancement if the child's under, I believe it's 2 years. If they're under 5 years, the age of the alleged victim is very important. It could really get sentencing exposure go through the roof. Certainly on sexual offenses, it's a lot more harsh than it would be on two adults. So, it all depends. Definitely, generally speaking, yes, they have higher penalties. Generally speaking, it's more difficult to negotiate a favorable outcome because you're dealing with a lot more emotion. You're dealing with possibly, if the case goes to trial, a lot more difficult task at hand to pick a fair and impartial jury. Because a lot of times my experience seeing child abuse cases, whether we have a good defense or not, jury hears of a sick kid or an injured child, and they're looking for someone to blame, in spite of what the evidence might say.
Gotcha. Okay. Well, for those of you watching, again, feel free to post your comments below or questions below, as even indicated in the video. If it's something that's more private in nature and you want to speak in generalities, that's fine. But if it's private, you can just reach out to David directly. Their office does provide a free consultation. With that said, David, I want to thank you for your time.
No problem. One thing I actually want to talk about, though, which you alluded to before, was the AVO reviews and the reviews online, and I think that's important because you want to match up the number of reviews a client has with what an attorney has with their experience too. I see a lot of people who've been doing this for about 6 months or 8 months, and they mysteriously have about 40, 50 reviews when they've represented about 20 people. So you got to be really careful about that. I've represented over 1,000 people in my career, and I have probably about 50, 60 reviews. That seems a little bit more normal than the person who's represented 100 people and has 50 positive reviews. So you want to take that with a grain of salt and make sure those numbers match up with that attorney's experience.
All right. Well, that's probably some good advice. Again, Dave, thanks for your time.
Thank you.